Welcome to our Law of Evidence video series, where today we get to look at character evidence as we endeavor to discover the fundamental facts of South African law of evidence. Thank you very much again for being part of today's presentation, and hope that you will find it both informative and inspiring. Now, let me say as we begin, remember to subscribe to the channel. Yes, click that subscription button and then click the notification button as well. Remember to like the videos and to share with your friends to promote the channel, particularly because I believe it's blessing you. That's why you keep coming back to it. Now, without further ado, let's go to the next item. Right, in the past, we have looked at, in fact, we already have videos on similar fact evidence, on previous consistent statements, hearsay evidence, opinion evidence, admissions, as well as confessions. Of course, that's beside the videos on the rules regarding the admissibility of evidence, where we speak about the criterion of relevance as the starting point. Otherwise, look out for all these other videos. They are there somewhere. If you can't find them, just notify me. I'll guide you in terms of how to locate them. Now, we are looking at character evidence in our current video, as I've already said. We ask ourselves the question, what is character? And then we are going to look at a definition that has been attempted by John Sopinka in a certain article whose details we are going to discuss below. But basically, we are saying we are looking at whether character evidence is relevant, and we are saying character speaks to the accuracy of the testimony or the credibility of witnesses, and we are saying that disposition and reputation are the main elements, or they are the two types of character that are important. By disposition, we mean the personality or the way the person really is. For instance, a person who regularly takes property that's not his own, that one is a thief. We can actually say this one is a thief. He steals. So that's disposition, and we are likely to, in future, when a theft has taken place, we could then say, we could assume that this person who habitually takes what's not his or her own has, again, in the particular circumstances, taken what's not their own. So that's character as disposition. And then we have character as reputation, what other people think about you. I believe every one of us is so fortunate that whether for good or for bad reasons, we have people who think certain things about us. For instance, I think you've watched so many of my videos now. If somebody asked you to speak about my character, you could probably say one or two things based on what you have been exposed to. So the same applies then to every one of us out there. So we have character in the form of reputation, the belief, or rather, yeah, the view that people have about you regarding what kind of a person you are. So we're asking ourselves the question whether it would be relevant to prove that an accused has a disposition or a proclivity to commit a certain crime. Is it fair? I don't know. It's up to you to think about that. Maybe as we proceed with the discussion, some of these things will come up. And so we are going to take note of the fact that the common law allows evidence of reputation and not of disposition. So evidence of reputation is normally accepted or admitted in court, whilst evidence of disposition is taken circumspectly. And then you will have to familiarize yourself with section 240 and 241 of the Criminal Procedure Act 51 of 1977. to understand how evidence of disposition gets to be admitted. So the question is character evidence viewed differently in criminal matters or as well as in civil matters? Do we view it in the same way? When we look at character evidence, is it relevant in defamation matters, breach of promise, divorce or fraud? Yes, of course. But we will discover that as we proceed. And then in criminal proceedings regarding receiving stolen property, yes, character evidence gets to be admitted. That is evidence of disposition, and that's what we are going to discover when we read section 240 as well as section 241 of the Criminal Procedure Act 51 of 1977. Yes, I did indicate earlier on that we are going to be looking at a definition of character that has been given to us by John Sopinka in one of these articles with the title Character Evidence in Civil Matters, or rather in Civil Cases. Now, let me contextualize this by saying Sopinka was writing from a Canadian perspective, and the article was published in the McGill Law Journal in 1972. That's volume 18, issue 3. You can actually look for it if you want to. Now, why Canadian evidence? You remember that Canadian law is common law also, with its foundations in English law, and taking into account that South Africa's law of evidence is actually born out of English rules of evidence, you'll understand why it may be very important to understand particularly issues from the point of view of a Canadian writer and Canadian jurisprudence. So this is how Sopinka defines evidence. He says, sorry, how he defines character. He says character is simply a compendious summary of a person's past actions, good and bad. So in other words, your character is a summary of the things that you have done, or the things that you are perceived to have done. The good things and the bad things all accumulate to build up what we may call your character. And we have said in terms of the common law, the principal concern is with the character of the person in the estimation of those who know the person. That is his or her reputation. So it's not so much about disposition, except in those exceptional cases. Remember, we spoke about section 240 as well as 241 of the Criminal Procedure Act. Otherwise, generally, whenever we talk about character in the context of evidence, it is mostly with the reputation that the law is concerned. And you find that in early history of the law, character was the major determinant of a person's fate in court. It was sufficient for people to just come in and say, oh yes, I know this person, she is such. And if you were described as a thief, everybody assumed that the things that had been stolen had actually been stolen by you, and so on and so forth. So character was a very strong determinant of the outcome of the case. And we are saying the character of a person, of course, is logically relevant to the facts in issue. For instance, a person who has in the past murdered, like a serial rapist, a serial murderer, when in future we find somebody has been murdered in the same fashion, there is a tendency to suspect the person who has done it before. And we are saying if this person has a propensity to commit rape, so in this particular case before the court, there is a likelihood that he or she's actually responsible for it. So we are saying the character of a person is logically relevant to the facts in issue. But you see, the prospect of prejudice arising from it may be so overwhelming Hence the strong argument for the exclusion of such evidence. And we are saying that the reputation of a person who has stolen goods in the past weighs heavily against them in evidence. I think we have already alluded to that part. That the reputation that you hold in the community where you are actually determines how people are going to view you in future, and whenever a similar offense is committed, people may want to believe that you are responsible for committing it, even if they don't have any sufficient evidence. Your character may actually be so damning, they might want to use that one as the basis for, a conviction. So we ask ourselves the question, under what circumstances may character evidence be admissible? So we are saying character evidence may be admissible to prove facts in issue. So in other words, it may serve as a secondary evidence, secondary material to prove facts in issue. Or, in fact, in some cases, character evidence may be the facts in issue itself. So when the character evidence constitutes the issues under the consideration of the court, then we say it is primary. We are going to look at the distinction between primary and secondary form of evidence below. Let's proceed straight and try to give that distinction. So when we talk about character as secondary evidence, we are saying that character may be tendered in proof or disproof of some other issue apart from character, or to show the doing or not doing of an act by the person against whom the evidence is being tendered. So if you talk about somebody who maybe has in the past committed an act of theft or rape or murder, in the light of the circumstances, it may be brought before the court as proof or as evidence that Mr. X has in the past committed A, B, C, D. So there's a likelihood that even in the current circumstances, he has done it. So it's evidence of the accused's good character, which raises a presumption that a person of good character would not commit the crime charged. So you see, it could be evidence of good character or evidence of bad character, but whichever way, in whatever circumstances, when it is provided as secondary material or secondary evidence, the character is being used, is being deployed to prove facts that have nothing to do with the character itself. So it renders it less probable that the prosecution's averments are correct if one demonstrates that the accused has a good character. So a person who's got a good character is less likely to commit certain offenses. And we are saying evidence of an accused's bad character would not be admissible except in exceptional circumstances. So you see, the law is trying to run away from a scenario where it ends up being a trial of character rather than a trial of the facts before the court. Because you see, it becomes a collateral matter when we start inquiring into whether the accused could have done A, B, C, D because she is of a character that is capable of doing A, B, C, D. Because it ends up being a program where we are delving into issues of disposition, trying to evaluate the disposition of the witness. We are saying in civil proceedings, character is excluded on the basis of being irrelevant and its prejudicial effect. But of course, there are certain circumstances where it gets to be admitted, as we shall see below. And the tendency for most parties is to introduce character evidence in cross-examination rather than in evidence in chief. Because there's a broader rule to say that, you see, more questions may be brought in to test the witness's credibility, but you cannot adduce character evidence as evidence in chief. But then maybe when you are seeking to, show the credibility of a witness, or the lack of credibility of the witness as cross-examination, you may then ask questions that border on the character. And we are saying if questions on character are asked to determine witness credibility, the opposing party must accept the witness's answer without rebuttal, except in certain limited circumstances. So it's like if in cross-examination, the cross-examiner asks the witness about her character. Maybe the cross-examiner asks a question like, have you ever stolen anything before in your life? And if the witness says, no, I've never done that, there's no need then for the cross-examiner to go ahead and adduce evidence to try and rebut that claim. So it must be taken as it is, because the court, the law says that there should be avoidance of pursuit of collateral issues and questions that tend to veer off from the main issues before the court. So the questions asked in cross-examination must be of such a nature that when an answer is given, it's taken at face value. Even if the cross-examiner is not convinced, they may not then lead evidence in rebuttal of that. So those are some of the things to take note of. So there are exceptional circumstances in which rebuttal may be permitted. Some of these the circumstances are the following. There may be rebuttal when a witness has maybe made a statement then to prove a charge of bias or partiality in favor of the opposite party. So a witness may have given a testimony, and then the cross-examiner may want to demonstrate that the witness has in the past acted in a way that shows partiality and bias towards the person in whose favor the witness is testifying. For instance, it may be relevant for the court to understand and to be informed that this particular witness has in the past maybe tried to induce other people to act in favor of the party in whose favor this particular witness is testifying. So under such circumstances, rebuttal can then be permitted in terms of court process. And then, so there may also be exceptional circumstances warranting, the proof that the witness has previously been convicted of a criminal offense. So if maybe the witness is asked whether he or she has been convicted, and then that witness declines, says, no, I have never been convicted, it may then be in the interest of the party doing the cross-examination to bring evidence in rebuttal to demonstrate that no, this witness has previously been convicted of an offense. Or in certain circumstances where medical evidence may be required to prove that the witness is of a certain mental or physical condition and therefore is unlikely to tell the truth. I think we've been seeing this unfold in is this the Mafe case, if you've been following the case regarding the banning of the South African Parliament in 2022 in January. So there is this Sandile Mafe gentleman who was arrested in connection with that and charged with arson and other charges related to the banning of the Parliament building. Now, one of the things that has actually been recurring, one of the issues is that his ability to answer questions is actually compromised by his mental state. So now evidence of his mental condition as a medical condition has actually been at the center of the postponement of the trial for over a year now. And so there may also be instances where there's need for independent evidence to indicate or confirm that an adverse witness has a general reputation for untruthfulness, and that the witness testifying to such reputation would not believe the impugned witness on his oath. So they may need to be, in some certain instances, proof to demonstrate that the witness is not a truthful witness. So under such circumstances, it may then be, the evidence may then be led to indicate and demonstrate that we are dealing with an untruthful witness here. And then where the proper foundation has been laid, a previous inconsistent statement may be proved to contradict a witness. Remember, we spoke about previous consistent statements in the past. So it may then be, if you want to understand, you may go up to that video on previous consistent statements to find out how they are admitted. And we are saying if all the rules regarding the admissibility of those previous consistent statements are met, then it may be worthwhile for the court to admit evidence in rebuttal. And we are saying parties must avoid wide-ranging cross-examination with respect to collateral matters which open up new and lengthy inquiries. So there is always, in the interest of justice and in the interest of time, to avoid these lengthy cross-examinations where issues collateral to the main issues are now being, investigated instead of sticking with the main issues. And we are saying in an action for fraud or deceit, character evidence may be admissible if it satisfies the rules for the admission of similar facts or similar fact evidence. Again, you may need to revisit the video on the admissibility of similar fact evidence. So far we spoke about character evidence as secondary evidence. But now I would like us to look at character evidence as primary evidence, because that's very important also to take note of. And we are saying in certain circumstances, character may be directly in issue either on the question of liability or on the quantum of damages. So it may be necessary, to inquire into the character as the main issue of the case. As you will see in the case of defamation, breach of promise to marry, seduction, and actions in which damages for adultery are claimed. So in the case of defamation, we are saying the character of the plaintiff is relevant to the facts in issue. Only one who has a good character is capable of being defamed. So in other words, when you claim that you have been defamed, that statement that's defamatory has been made, you may then have to indicate and demonstrate that you have a good name, and that good name has been tarnished by this publication of defamatory information by the person, whoever the defendant is. So we are saying, meanwhile, the defendant can, in support of a plea of justification, adduce evidence of the specific acts to prove that the alleged defamatory statement is true. So it's like, if the plaintiff claims that their good name has been tarnished and defamed, the defendant may then adduce evidence to prove that no, there was not defamation in this case, because this statement that I have made is actually true. So maybe you can revisit your module on the law of delicto tort, where issues of defamation do arise, issues of damaging, or rather, defaming the name and the character and bringing disrepute in the name of a person. So those issues would arise, and we are saying the defendant is allowed in law to lead evidence to demonstrate that the statement that he or she made about the plaintiff was actually true and in the best interest of truth and society. And then in the cases of breach to marry, evidence of the plaintiff's bad character may be adduced. For instance, let's say A and B had undertaken maybe to marry, they had that promise to marry one another, and then in the course of time, maybe A decides to cancel the arrangement. Then B now goes out as a plaintiff, and then is claiming maybe damages, for breach of promise to marry and so on. And then A now adduces evidence that the reason for the cancellation of the promise, the reason for reneging on the promise, was to do with the fact that the plaintiff is of a questionable character, and so the defendant was no longer willing to take the risk of marrying such a person of a questionable credibility and character. So in that case, it may be competent for the defendant to raise questions based on the bad character of the plaintiff. Now, in the case of seduction, as you read section 227 and 227 of the Criminal Procedure Act, some of these things may come right, or may come out clearly, of course. But here we are talking about seduction as in, taking a virgin. It used to be a very important and central part of the law in the past, where for a man to have sexual intercourse with a virgin could actually result in liability. So we are saying the defendant can adduce evidence of general reputation for the immorality, it used to be, of the immorality of the person whom he is accused to have seduced. And so it may demonstrate that prior to seduction, this person was no longer chaste. She had been everywhere, she had lost her virginity, and so on and so forth. But now you'll notice in terms of section 227 that the character of the victim of rape is not relevant, and making any insinuations or asking questions about the previous sexual experience of the victim of rape is actually unacceptable and unethical, as it would actually discourage people from reporting on matters of rape and so on. Then we are also saying that in actions in which damages for adultery are claimed, there may then be evidence regarding previous immoral character of the parties. For instance, it could be a woman who is claiming damages for adultery against her husband, and then the husband may prove that the reason why he had to now be involved in affairs with other women had to do with the fact that the wife had in the first place been immoral. So the husband then claims that he has been kind of retaliating or trying to get even, or he was upset by the adulterous conduct of the other spouse. So they may then be leading of evidence to justify the adultery. Of course, it may not be something morally justifiable, but you understand what I'm saying. So previous immoral character such as adultery may be proved, and the defendant may equally prove that the plaintiff had also been unfaithful. So both parties in this case may lead character evidence, because by claiming, in fact, by claiming that the other spouse has committed adultery, the plaintiff is already speaking about the character of that spouse. And also the response of the other spouse to say, no, I'm not the one who started this whole thing. It's also speaking to the character. So character evidence does get to be thrown around in such cases, and it is admissible. So coming back now to talk about character evidence in terms of Criminal Procedure Act, we are saying Section 197 of the Criminal Procedure Act 51 of 1977 talks about the privileges of the accused when giving evidence. And it says that an accused person who gives evidence at criminal proceedings shall not be asked or required to answer any questions tending to show that he or she has been previously convicted or has been charged with any offense other than the one which he or she is being charged, just to demonstrate that the person is of a bad character. So that is not that is prohibited in terms of Section 197, except of course in some exceptions as we have them here. If the accused attempts to prove his own good character or attacks the character of another witness, making an imputation of bad character of another witness, then he or his legal in this case he or his legal representative asking questions of the other witness, with the intention to show the bad character of the other witness, or the nature of the conduct of the defenses such as to involve imputation of the character of the complaint. So character questions, character evidence may then be led. So in other words, if the witness tries to demonstrate that the other witness has a bad character, then that kind of destroys the fence that they may have regarding the protection of their own character. So now it may be competent for the other party to also inquire into their own character. So if the accused testifies against the co-accused and gives evidence against any other person charged with the same offense, or an offense in respect of the same facts, it may then be competent to inquire into that person's character. It's also an exception when the proceedings against the witness are such as prescribed in Section 240 and 241, which deal with evidence of having received stolen property previously, and the other notice under the sections has been given. So in other words, if in the past one has been maybe convicted or found to have been in possession of property, stolen property, and then it so happens in a subsequent trial on a different issue that the accused has again been found in possession of stolen property, then it may be competent for the prosecution to prove that this accused has in the past been, found in possession of stolen property. There's also another exception to do with, if the current trial is based on a breach regarding a previous offense, or a proof that X has committed or has been convicted of such an offense is admissible. I'm thinking here about the case of Thabo Bester, who escaped in prison and then was out living under a disguised character for over 10 months, and then was eventually arrested in Tanzania trying to flee from South Africa. So in the subsequent trial, would it be competent for the court to be informed that this person has been convicted before, escaped from prison, and tried to flee and so on? Well, obviously, the next, if he's convicted, if he is charged with escaping from prison, then it goes without saying that there has to be proof that he was lawfully incarcerated previously and he escaped from lawful custody. There's just no way the court would know and establish whether really he is guilty of the offense of escaping from lawful custody unless there is proof of previous lawful conviction and so on. So those are some of the exceptions to this 197 protection of the witness's privilege. There's also an issue of section 211, evidence during criminal proceedings of previous convictions. The law says that except where otherwise expressly provided by this Act or the Child Justice Act of 2008, or except where the fact of the previous conviction is an element of any offense with which an accused is charged, evidence shall not be admissible at criminal proceedings in respect of any of the offenses to which that accused at such proceedings had previously been convicted of any offense, whether in the Republic or elsewhere, and no accused is called as a witness, if called as a witness rather, shall be asked whether he or she has been so convicted. Now you notice that in terms of the Child Justice Act, a person who has been previously convicted maybe for sexually abusing children and minors, that matter should be brought to the attention of the court in spite of the prejudice that it may seem to import against the accused. So that's one of those exceptions to say, while section 211 says people should not be accused should not be asked about their previous convictions, there is an exception to say in matters relating to child abuse and child sexual offenses and so on, that accused must actually, in fact, that evidence must be brought before the court to actually assist the court to determine whether indeed the accused may have committed the X charge, the X charged. So when we look at the character of the accused versus the character of the complainant, that is in terms of section 227, which we spoke about earlier on, we notice that the accused is always entitled to adduce character evidence which would be admissible, even if its evidential value is not substantial. So the accused is actually not prohibited from adducing character evidence, to demonstrate that they have a good character. And we are saying that section 227 deals with the character of the complaint or the aggrieved person. And you wonder if the character of the complaint or the aggrieved person is relevant in this case. Of course, we've heard some people trying to justify instances of rape by maybe saying that the woman was raped because she was dressed in a short miniskirt body, revealing the whole body and so on. That kind of thinking is intolerable. To say that somebody invited the commission of a crime against themselves through the way they were dressed. So we are saying the character of the complainant is hardly relevant to the facts in issue, because that would amount to saying that they volunteered themselves into the problem that they eventually face. And we are saying section 227.2 states that no evidence about the sexual experience of the victim shall be adduced, except that evidence connected with the matter being tried. So in other words, if a man is charged, accused of raping a woman or seducing a young person, child, it would not be sufficient to then say, but this person already had sexual experiences before, so I shouldn't be held accountable for what happened. So the section 227.2 says that inquiring into the sexual experience of a rape victim is actually intolerable and unwarranted. So we are saying the defense cannot, except with the leave of court, adduce evidence that the rape victim was no longer a virgin. How would that assist? How would that avail the rapist anyway? Because rape is unlawful and intentional intercourse with a woman or with a person without their consent. So how does their previous sexual experience then cancel all those other requirements? Like, does it introduce consent? No, it doesn't. So why even bother talking about it? So you can inquire, or rather look at the case of S versus M 2003 to confirm some of these issues that we have discussed. Now, so there has to be application to present character evidence of the complaint, and it will be granted if the evidence or questioning is in the interest of justice with due regard to the accused's right to a fair trial. Yes, sometimes because the accused has a right to a fair trial, it may actually be in the interest of justice to have some character evidence adduced or presented. So application to present character evidence may be granted if it is in the interest of society in encouraging. In fact, remember, it is in the interest of society to encourage reporting of crime. So we then ask ourselves the question, by allowing the accused maybe to lead the character evidence of the complainant, does it then place the complainants in similar circumstances at a point where they can confidently want to report crime? So those are factors to be taken into account. So if it is in the interest of society to prevent the accused from presenting character evidence, then it would be appropriate to do so. The court will also have to consider whether the evidence relates to specific instances of the sexual activity relevant to the facts in issue. So, in other words, are the issues being inquired on relevant to the issues before the court? The other question is the evidence likely to rebut evidence previously adduced by the prosecution? Does it add any value? And the other question is it fundamental to the accused's defense? There may be instances where adducing such evidence would be, fundamental to the accused's defense. So they may want to lead evidence in that regard. And then again, it may be permitted if, after substantially weighing the issues, the potential for prejudice to the complainant's personal dignity and rights to privacy are not compromised. In other words, it can be allowed if the complainant's personal dignity will not be greatly compromised, or it can the application can be granted if it is likely to explain, if that evidence is likely to explain the presence of semen or source of pregnancy or disease or injury to the complainant where it is relevant to the issue. So those are some of the isolated circumstances or exceptions or factors that the courts will consider in determining whether to grant the application for leave to adduce evidence of the character of the victim in the circumstances. So having gone through, we've come to the conclusion of our video. It has been informative, a roller coaster, I must say, covered a lot of things. I suggest that you go back to it again and again and again and listen to what it has said. But the bottom line is, maybe the main issues is that the character of a witness is almost always relevant to determine the credibility of the witness. We are saying character consists of disposition and reputation, and we are saying in certain circumstances character may be a primary source of evidence, being the matter to be determined in the decision of the case, or it may be secondary evidence to prove what has occurred or not occurred. And we are saying character is often excluded to mitigate its prejudicial effect to the parties. So as we noted that sometimes character evidence may be quite prejudicial, so it may have to be excluded. And it is admissible in terms of certain strictly circumscribed rules in circumstances. Thank you very much. We've come to the end of the video. Once again, thank you very much again for being part of the broadcast. And may I ask you, if you've not already done so, to subscribe to the channel iClass Virtual, and then to like the video, this video, and to like all the other videos that you view, and to share the videos with your friend. Spread the word around that we have this channel and it's helping a lot of people. A lot of people have actually graduated from their courses, and they've been sharing their experiences with me. I would love to hear from you also. Please take note of our details and follow us and write to us. Thank you very much. Enjoy the rest of your day. Bye-bye.